My lawyers appreciate it.
Now, it is correct to say that the case against the first and second defendants is for non-compliance with their statutory obligations. That is correct.
Your line is still fluctuating. Your line punctuates, it is not free-flowing. However, I think I would say yes to what you just asked now, but your line punctures your speech, maybe the network. Yes.
This case against the first and second defendants is for non-compliance with statutory obligations.
Yes.
No, with that is the first and second defendants' statutory obligations. We just want to establish there is actually no case against us. Yes, doctor. Are you the only one that was affected by this alleged non-compliance?
I wouldn't know. I'm not the manager or the director. I'm just I was a staff with them for that period, so I wouldn't know whether I'm the only one affected or not. What I know is that they did not pay my pension to my PFA, who is Leadway Assurance, and then based on the pay as you earn everything, they didn't pay it, and some other issues. They didn't pay my leave allowance. They didn't pay so many things. So they didn't pay me. I don't know about other stuff. I'm only looking. It's a private firm, so it's not a government where you do a luta or unionism. So I'm taking care of myself.
Thank you. Yes. Doctor, will you be surprised to hear that some others were also affected by the same complaint that you have laid before this court? Would you be surprised?
I may not be surprised. I may not be surprised if I hear, because I remember that this matter, I raised it with the firm, and I got some inkling that some other, it seems so one or two people also said they have not received. So I don't know whether they now received later, because I left the company. So I don't know, but while I was raising this issue, some people also said they are also not opportune to be paid, and they're also pushing their own. So I don't know whether.
Doctor, I beg you to note that the court is recording your response to these questions. So you may do us well by just having to be a bit slow so that it could be properly recorded.
Okay, no problem. Oh.
You asked him whether he would be surprised if he found that 4 other people were also affected, and he said he may not be surprised. I don't want to go beyond that.
That's correct. Thank you, my lord. Thank you.
That is his opinion. I mean, yes.
Now, are you aware that the third defendant had assigned a recovery agent to the first defendant for a pension audit?
Is that pleaded in your statement of defense? What paragraph?
I'm not aware. I'm not aware.
All is printed in okay, this is the house.
You are not aware, doctor?
Yes, I'm not aware.
It's pleaded in paragraph 7 and 8 of the defense, statement of defense of the third defendant. Specifically paragraph 5.
Of a recovery agent.
Yes. That is one Mark on Nojake and Co. It's stated in paragraph 5.
Yes.
So, Doc, are you aware that the third defendant, if indeed the recovery agent,
he said he's not aware. I've recorded that.
has stopped business?
Yes.
Now, would you be surprised if we show you evidence that an investigation has been conducted on your allegation?
Will I be what? Surprised or aware?
I am asking, are you aware that an investigation has been conducted on your allegation?
Yeah, I may not be surprised because I think it's the duty of the third defendant to conduct that if they have done it, because it's their legal obligation to carry that out.
Thank you very much, George.
Because not getting you. Did you ask him whether he'll be surprised or whether he is aware?
I'm asking Dr. Ude, are you aware that the third defendant conducted an investigation on the allegation?
I'm not aware.
Dr. Ude? You bring me back to the fact whether you have seen the defense and attachments front-loaded by the third defendant. Yes, ma'am. Yes. Okay, that's all. Yes. Doctor.
Yes.
There is an attachment to the statement of defense of the third defendant, which is a letter to the first defendant, Medivation Health Limited, introducing the recovery agent based on your complaint. I want my lord.
Your investigation, your setting up somebody this consideration would not be alone to bring this fact. Yes, they is becoming aware that there is something. I think when the post that how far you read the updated. Yes, you have down and the update
He also did not go for that because of his case. There are several other complaints from other individuals relating to the same subject matter. That was the reason why we stopped the meeting at that point, because that's the position I got. A lot who had wanted to utilize this opportunity to end the matter at this point and not bother bringing a witness. That's the reason why I'm laying foundation for all this, and I'm done. I'm actually done. Yes, my lord. The engagement of the recovery agent, Mark or not?
Yes, because that fact you have already stated.
Yes.
That first of all, he wouldn't know whether he's the only one affected or not. All he knows is that they didn't pay him, and he's speaking for himself alone. He may not be surprised that other people were also affected. Then he is not aware that the third defendant has engaged the services of a recovery agent. He is also not aware that the third defendant conducted an investigation into his allegation. At that point, because now you have brought those facts to the fore, which he now knows. If there was a further development, this is the time to say, maybe, are you aware they have the investigation has been concluded, and the result is this? Then we know we are going somewhere, because you only said you briefed a recovery agent. We have not heard anything about the activity of the recovery agent. None of it is pleaded.
My lord,
yes.
Looking at the state of the claim against the third patient,
yes.
The only issue here is that we did not undertake our statutory obligation for him. That's just all.
He did not.
The claim against the third defendant.
The third defendant.
My lord, in their reliefs, paragraph F, clearly said a declaration that the third defendant is mandated by law to investigate the complaint of the claimant in respect of the non-remittance of his pension funds by the first defendant and give appropriate directions. That's the only claim against us.
Okay, I get you.
So that's the only reason why we said to that extent we have done our bits.
Okay. So you want it to be, if you want him to be informed that you have written, you have engaged. So haven't asked him whether he is aware, and him haven't said he is not aware. You now make him aware that there is a letter dated 7 July 2023 by which you engaged a recovery agent. It's up to you.
Doctor.
Yes, yes.
The position of the third defendant is to make you aware that the third defendant had, in response to your complaint, commenced an investigation .
The line is breaking. It's a bit off top, okay? Can you hear me?
Hear me?
I can hear you. I can hear you now. Yes, yes.
Yes. So I'm saying the third defendant wants to bring to your notice that by virtue of a letter of 7th July 2023, that it had commenced investigation to your allegation.
Okay. can you hear me? Can I say something?
Yes.
Yes, please go ahead.
Okay. Just like our lordship said, the third defendant commenced investigation on the 7th of July 2023, and that is your due diligence, your duty, to once in a while make sure that these companies are doing what they're supposed to do. And 7th July is like 18 months ago, or 19 months now. I've not received my pension. I don't know anything about recovery agents. I don't know what has been done. The most I know that my pension, I still went to my PFA some days back, and I did not see my pension. It has not been paid for the almost 2 years I work with that firm. So I want to know, what has the investigation that you triggered since 7th of July? Why hasn't he yielded my pension till today? What sanctions have you given them? Can I see copies of the sanctions? Because I know there are sanctions based on the Pension Act, those that are defaulting. Have you pensioned them? Have you sanctioned them? What penalty have they done? It's what I want to hear. And where's my pension?
Okay, I think the message is properly communicated. I recorded it as you putting it to him that the position of the third defendant is to make you aware that the third defendant has commenced investigation, and by a letter dated 7 July 2023 attached to your statement of defense, you have briefed a recovery agent. And the doctor is saying all he knows is that he has not been paid his benefits, that he does not know if they have done anything in that regard. Doctor, is that what you said?
That's it. That's what I say. And there should be interest. According to the Pension Act, there should be interest on my pension by now to be paid double. And you know the Pension Act. So where is the money?
And you are saying that you are entitled to your pension and interest there too.
Yes, that's what I want to. That's why I'm
Thank
here.
you. Okay.
Thank you, Dr. Day. That's why you are in court, to get justice, and it will be done for you. Thank you so much.
With interest, go to the Pension Act.
That's all for the witness, my lord.
Can I say something? Can I still say something, my lord? Can I say something?
the case against the defendants, one would naturally expect that when constituents have played the role as a defendant, it would have been appropriate to have subpoenaed us and come in and assist with the computation of the penalties.
A very responsible role.
That's right.
And most importantly, from your defense, you don't have the intention of abdicating your responsibility. And this is what we need when we need to be sure. Because going and the federal government against the second defendants without their participation. Yes, deliver the way. And we have quite a lot of success in our like let's begin the choice so that by the time we come, there will be a change.
I don't have a question.
Because right now, the next step I need to take is to adjourn it to enable the first and second defendant process that we control.
I cannot foreclose them. That's testified.
So I think one step
To inform them. I'm making an order remitting this case to the ADR center. Usually they have a time frame, 21 days, within which to do all they need to do. And they give me a report before the next adjourn date. So by the next adjourn date, if we have made progress, we'll settle the matter and we'll get them to pay. Because if they have agreed to pay, and you will enter terms of settlement, which I will enter as consent judgment. All right? And then we can now talk about enforcement. Because the cooperation we need, the third defendant's cooperation is very vital to the mediation. You understand? If they have gone to the extent of hiring a recovery agent to recover monies for different pay, for people who are recalcitrant, from the organizations who are recalcitrant, it means they have taken a step in the right direction. And then added to the pressure coming from the courts, they just might want to say, okay, let's just single this one out and pay. At least let's get off this. And then let's give it a shot. I think it's worth the trouble. What do you say? What do you say? Did I say it won't keep on going? No, you don't seem to understand what I just said. Dr. Ode, are you there? No, I want him to hear.
I'm here. I'm here, ma'am.
What I am saying is that now here in this court, we have an in-house mediation center. And somehow our mediator has recorded quite a number of successes when it comes to cases like this, even when the parties refuse to come to court. When they send them hearing notices direct to the officers, they come and then they sit on mediation, they hold syndicate sessions, they might need to reach you online to have conversations with you. And then by the time we have the third defendant, but we are going to also invite the third defendant for this mediation. and everything is concluded that, okay, yes, it is true. This, because you see, it makes the work a lot easier. For as long as we continue to send them hearing notices and they don't come, the best we can do to them is to deliver judgment against them in their absence. And then the issue of enforcement will still arise. But if we try this mediation method, you might just get settlement even before the next adjourn date. So I am going to adjourn the matter for continuation of hearing, because the first and second defendants, even though they are not here, they have a right to cross-examine. We must have adjourned purposely for that cross-examination, and their failure to come will now compel me to foreclose them, and then we'll open a defense. You understand? So we are not losing time at all. The time in between now and when we are coming back is the time I want us to send the matter to mediation. They do whatever they can do with it. If they record success, they send us a report. We succeeded in mediating, and this is what we have agreed. They reduce it into terms of settlement. You take a look at it. If it's acceptable to you, fine. And then we enter it as consent judgment. And that consent judgment can be enforced because they are a party to it. It's not as if we cannot enforce judgment obtained by adjudication. We can, but we are going to be doing it forcefully.
I think I
Yes. Unmute your mic so that he can hear you. Yes. Yes, you need to unmute your mic.
But today, can you hear me?
I'm sure he's hearing.
Okay.
I hear you. I hear you. Yeah.
The third defendant is willing to assist the court to ensure that you get justice in this matter. And the third defendant would like to apply for the matter to be sent to an arbitration of this mediation of this same court, after which can continue. There is no progress. We so submit.
Dr. Ode, are you okay with what I suggested?
Yeah, I'm okay. I have a question before I answer. Can I ask a question?
Okay, yes, please.
No, the third defendant is here, which is the PENCOM.
PENCOM, yes.
Let's remember that this firm I worked with, they are owing me lots of money. Pension is just one. Pension is just one thing they're owing me. They're owing me lots of money. So pension is just one out of many. And we're just talking about pension.
The one that PENCOM represents.
What of the other money? Pension is
That's
just
why
one.
We want to
what is this
them.
suit is pension. The pension, my medical bills, my leave allowance, all these things are contractual and they are meant to pay me. So we're only discussing pension.
Because it is only PENCOM that is here with us. We cannot discuss your other entitlements with PENCOM. The only thing that PENCOM can do for you is pension. And that's why I said, let's invite them over. At least the area of pension, PENCOM will ensure that they are able to agree. Even if they agree and they pay your pension, we can continue the matter to prove the remaining part of your case. At least you would have collected your pension.
Okay, my lord, thank you.
The mediation is not limited to pension. It's limited to your entire case.
Okay. Thank you, my lord. Thank you, my lord.
Yes. Yes, yes. Yes. Thank you. Thank you. Thank you. So I need to get your consent now before I make the order and see what I wrote. The next thing is for the matter to be adjourned to enable the first and second defendants to cross-examine the witness. However, I have reviewed the case, the pleadings and evidence adduced, and I am of the view that this matter is one that can be settled amicably. I have asked counsel on both sides, and they are not averse to settlement. The claimant to participating online is not averse. Is that the position? To settle. Why is it that my dream comes to that? So, Dr. I was dealing with you when I read the record, and I'm asking you if you agree to for us to give settlement a chance.
Yes, I agree.
Okay.
Yes, my lord.
Thank you. So usually the mediation center has 21 day basic. If there is progress, there could be an extension. So I'm just going to adjourn the matter, and then when we come back, we'll have a report awaiting us. So when do you want to come back? 18th. No, I need to. It's going to be virtual again. Okay. Mr. Mohammed, let's look for one day for virtual. Àti kúkú fẹ́ máa fi virtual àti Friday ní báyìí báwo. Monday 24. I don't know what your Monday is like, 24th of March. To be looking on Thursdays because of 24th of March, Monday. Or would you do the Friday 28th? You want an earlier date? 21st. I don't like to do virtual and physical together. Today's scenario was an exception. Friday 21st. It's convenient. 11 o'clock. Mr. Dr. 21st of March.
Yes, my lord. Yes, my lord.
Oh, I'm not even looking at February. Looking at February. I don't look at February. You yourself, look at it. 21st of March. It's convenient. Oh yeah, they both fall on Friday. 21st of March. You need to give it time now. 21st of February. Today is 24th. You wouldn't have achieved much within that time. 21st March.
I'll be 1 o'clock.
Okay, so that's our meeting.
This matter is
hereby referred to the NIC and ADR Center for mediation. Parties are urged to be flexible and positive in this bid. The mediator is ordered to handle this matter with the speed and diligence it deserves. A mediation report shall be made available on or before the next adjourned date, reporting settlement or failure to settle. In the event that settlement is achieved, terms of settlement will be entered as consent judgment. In the event that settlement fails, trial will continue. The case is adjourned to 21st March 2025 for report of settlement. Hearing will again be virtual. In the event that settlement fails, CW 2025 for report
CW1 will be first examined by the first and second defendants. That was
so 21st March, 11 o'clock. That's it. So that's where we are with your matter. Hope to see you again on the 21st of March. You are going to be called upon by the mediator at any point in time while
mediation is ongoing. So you can always give them, convenient timing. A relaxed atmosphere. It doesn't have to be an office environment. You can be relaxed in your sitting room while you have those. And then I always encourage that the parties themselves participate in those mediations. Why I say so is because sometimes counsel can be quite rigid. So when you are mediating, take a back seat and allow the parties to, Of course, you can come in sometimes to prevail on your clients, to be flexible. I hope everything is understood, Dr. Ude.
Yes, my lord. Yes, my lord. Everything is fine.
Okay.
Yes.
Okay. So the case is adjourned. Thank you.
Thank you. The other matter is at one.
Yes. Okay, the court is right.